I would now like to turn it over to Bruce Kulick, who's a member of the committee, former general counsel at Merck, and he will introduce our first session of the day, a fireside chat.
Thanks, Mimi, and welcome everybody. It's a little warm in DC for an actual fire, so that you'll just have to imagine it behind me. In this session, we're going to look at the product liability considerations that can affect the decision whether or not to conduct clinical research in pregnant and lactating populations. And with us by Zoom is S1 Beisner, who is the head of the Mass Torts and Class Action Group at the law firm of Skadden Arps. You'll find a short bio in the materials. What should come across but isn't expressly stated is that John is widely regarded as the nation's preeminent class action defense lawyer. I had the good fortune to work with him on the defense of the Vioxx litigation when I was at Merck, and I'm delighted that he's able to join us today. And in the absence of an actual plaintiff's lawyer to join us in this chat, John is taking on double duty and will also from time to time put on a plaintiff's lawyer's hat and try to provide that perspective as well. We'll see how he does. I'm confident that John will help us identify and explore the relevant product liability issues, as well as placing them in the broader context of how lawyers work with their clients in the research community, and the other factors that can influence the decision whether to conduct this research in any particular circumstances. We'll have a discussion for about 15 minutes and then open it up for questions, and I hope you'll have those for us, because this is really a terrific opportunity to look at these issues. And with that, John, let me turn it over to you, please.
Sure. Well, thank you, Bruce, and thank you to all of you there for the invitation to participate in today's meeting. It's not a topic that I have previously spent considerable time thinking about, but certainly have looked at the literature in more detail now, and it's a fascinating topic and a very important one, I think. Let me start, Bruce, by just saying that some limitations on what I will be able to offer today. As you noted, I am a lawyer who works in the product liability arena, so I have some expertise there, but I don't want to be holding myself out as an expert in the design of clinical studies or the regulatory environment. I certainly have exposure to those things in my practice, but there are many of you in the room who are far more knowledgeable on those subjects, so I don't want to purport to have any special knowledge in that regard. But let me start with a general observation in looking at the subject matter here and the materials that I've reviewed. The thing that comes through in what I've looked at is a very strong assumption in the literature that the risk of liability is a strong motivation, a strong factor in decisions to exclude pregnant persons from clinical studies. Now, let me stop and just note that I think we need to consider the existence of several different types of clinical studies, and I think they'd probably fall into two categories from the perspective that we're looking at. Obviously, there are going to be studies with respect to potentially marketable products that are aimed at, or at least in part aimed at, conditions that are experienced by pregnant persons in particular, or that pregnant persons are among a major population, the overall population, who might use the particular product. And I think in those instances, there would be a greater inclination, for obvious reasons, of the need to have experience from those individuals to obtain FDA approval for the product. So I'm going to be focusing with my comments more on potential products that are going into a clinical trial phase that are more likely to be used by the general population, including pregnant persons. And in that realm, I guess I saw in the literature a consistent theme that product liability concerns, particularly with respect to consequences to the fetus in among pregnant persons to resist inclusion in clinical studies. But I just wanted to offer the initial observation that I am somewhat dubious of that proposition. Obviously, I'm not in the room when decisions are made by those dealing with the design of clinical studies about inclusions and exclusions of subjects. But I don't sense or hear in my conversations with clients on that subject a preoccupation with product liability concerns in the design of the decisions that are being made about including pregnant persons in those studies. I don't want to say that companies ignore that. There are certainly lawsuits that are brought by participants in clinical studies on occasion, and so that's. I don't want to suggest in any way that is not something that is given attention, but I really have some doubt that it's the strongest motivating factor in all of this, and I suspect that it has more to do with other considerations that are taken into account in making, in resolving questions of inclusion or exclusion of certain groups to such studies, having to do more with concern about risks, heightened risks to participants in the studies, the complications of the inclusion of certain populations. And here I'm talking more broadly about persons above a certain age, persons with multiple indications that may complicate the studies and so on. In sum, Bruce, I guess I would start just sort of raising the question that if we were all able to wave a magic wand and say that there would be no liability available, no liability that would arise from the inclusion of pregnant persons in clinical studies, I'm not all that sure that it would change the decision-making about including those individuals in the study. So that's in these studies. So that's where I would start.
Thanks, John. I think that's a really important point, and we'll probably be returning to it here and throughout the day. Could we unpack the liability issues, though, to the extent that they do exist a little bit? And I think one threshold question that is frequently asked is if you do have a drug for a general condition, say diabetes or hypertension or something like that, and it's indicated for the adult population, not contraindicated in the pregnant population, but not specifically recommended for that population, would a company increase its risks or decrease its risks by studying the drug in that population and putting information in the label about it?
I think that although it may seem counterintuitive, it may actually increase its risks. Well, let's think about what happens when you have a lawsuit that is filed with respect to a product. There can be a number of theories of liability, but what we normally see is not an allegation that insufficient study was made of the product. It tends to be more that the company began receiving reports about the product once it's in distribution of side effects that were not handled properly. In other words, that there was insufficient reporting at that point to the FDA. There was a delay in making proposals, perhaps to change labeling. But the idea that there was insufficient study with respect to the product, I don't see as a common theory in product liability cases. And I think the reason for that is that when you get into litigation about prescription drugs, the FDA is the core character in this. And in litigation, if you're a defendant and the FDA has approved the product for general usage, that's the fundamental issue. That's the fundamental position that you're going to argue to the jury. The FDA approved this, and it approved it based on whatever studies and information that it deemed appropriate to consider. And with the approval, it implicitly made the decision that it had sufficient information to determine that the product was safe and efficacious. And the concern I have is if a company, having received that approval, goes off and does additional studies at that point, you may actually be exposing yourself to a plaintiff's attorney, and I say this with all due respect in representing their clients as they should, of coming in and raising a lot of criticisms of the whatever additional study or studies might be done regarding the product with respect to a particular population. And that you purely in terms of defending the lawsuit, that you may well be better served by simply standing on the ground that here was the record the FDA considered. It made the determination that the product should be approved. It put whatever limitations it thought were appropriate on the label, and it's the boss in this area, and its determinations on this should be respected by the court. So there's some risk that you'll create more risk by doing more studies.
And in terms of that risk, and you can see this either from the plaintiff's standpoint in terms of what makes a sympathetic plaintiff, or the defendant's standpoint in terms of what increases the risk. Could you talk a little bit about how the risks are maybe heightened with respect to injuries to a fetus or to a pregnant person from a drug, as opposed to kind of the ordinary run of adverse events that can be serious but occur in a different adult population?
Well, those risks are serious, as you say, and obviously are of great concern in the industry. We've seen over the years several examples of that, which turned into major litigation and major controversies. But the risk is that you have a fetus that may be injured allegedly by the drug. Birth occurs, and you then have an individual that has limitations going forward based on whatever effect the drug allegedly may have had to the fetus pre-birth. These are lifetime afflictions in many cases that result, and can be an extreme range of liabilities that come out of that. But it's a serious problem for the company. The cases are very sympathetic because you have an individual who going forward may have very significant disabilities and be in need of considerable support from the family and others. And so those lawsuits are a very serious problem for a defendant if they come.
And there's a comment in the chat, and I want to apologize. We've been referring to the pregnant persons. We are also looking at lactating persons and populations as well, and I do believe many of the same factors could apply there as well. One other factor, if you could talk about, I think relates to the background risk of harm during a pregnancy or in the neonatal or perinatal phase, during lactation, breastfeeding as well, that because of these background risks, there will be questions of causation that come up. And could you talk a little bit, just for a couple minutes, and then we'll turn it over for questions, about how courts approach causation and why this might be a particularly challenging area for defendants?
Yes. Causation in product liability cases is often the primary battleground. And if you were talking about lawsuits alleging defects, if you will, in pharmaceutical products, if you're looking at an adult, you obviously, in litigating the case, are going to be raising a number of other potential causational factors. The person, for example, if the drug is alleged to have caused heart attacks, you will look at the history of the individual to determine if that person has already experienced some heart problems. A patient, a plaintiff who smokes, is going to be subject to a lot of arguments about alternative causation. If the individual is obese, that's often an issue in these cases. In short, what the defendant often does in those cases is point to a lot of other potential causations, in essence saying this person would have experienced this health event that is allegedly attributable to the drug, regardless of whether the drug had been taken. When you are talking about young children and so on, and the allegation is that during when the child before birth was exposed to something that may have affected development and so on, those other factors are much harder to identify. A jury is going to believe that the risk that drug played a role in whatever impairment is alleged, it's going to be much higher because there's no health history you can point to. There are no characteristics of the individual that you can point to as an alternative causation. And so I think that's the point of your question, that the difficulty of arguing for an alternative causation is much more difficult for a defendant in that circumstance. Doesn't say there aren't any, and doesn't say that arguments aren't available, but they're more difficult to make.
Thanks, John. I've got a number of other questions, but I suspect committee members do too, and hopefully they aren't shy. So maybe we could turn it over and ask folks. I think Alex had his card turned first, and then we'll go to Patricia.
Thank you, and thank you very much for that introduction to the subject. I have a series of questions. I want to make sure that I understood your view that if you were talking about the category of drugs that are not specifically for pregnant or lactating persons, and you believe that from your experience representing clients, they would be likely not to include pregnant or lactating persons. I wasn't clear whether you said as a general matter they would then want the label to say something about that, or if in the general view of the learned intermediary and the FDA doesn't regulate the practice of medicine, they would simply let it be licensed and leave it to the judgment of individual physicians.
Well, I think that, I think the assumption would be that the FDA in the label would be disclosing, as they normally do, the research that is available, and that it may well indicate that by what's in the label that there has not been there have not been clinical studies that included pregnant persons. And, I think I don't know if would be a strong preference among companies about what is said in that regard, but my assumption is that the FDA would make clear who has been excluded from the clinical studies that were done so that the learned intermediaries would know that the information that the FDA was using in order to make its determinations about safety and efficacy was limited in that way.
And if someone, before the fact, one of your previous clients came to you and said, what would be your view on defending a possible suit by a person in that excluded category to whom the drug was prescribed and who then alleged a harm from it, would you say, yes, that's a good defense, we can get that kind of case dismissed because we made it clear, not tested, it's between the doctor and the patient?
Well, again, I think what the company's position would be in that circumstance would be deference to the FDA, that the FDA was making the decision on this as it is empowered and required by statute to do, that it had the option to say we're not going to recommend usage of this product by certain individuals because of the lack of clinical study information. But I think that in defending the case, the normal practice would be to embrace what the FDA determinations were and defend the product on that ground. And if the FDA concluded that the record of clinical studies was sufficient to approve the use of the product with whatever qualifications it put on the label, that would be your defense of the product. And I think it's difficult in that circumstance for a plaintiff to say the company should have done more, the company should have done more testing and so on, because it's the FDA's process and courts generally are deferential to it.
So,
And
Alex,
can I just follow?
one more, okay.
Well, all right.
And we can circle back.
Okay. I wanted to understand whether your further view about this was that the situation changes if the company gets reports that the drug has been prescribed and these adverse results are showing up. And at that point, is that limiting statement that the FDA included in the label enough? Or I wasn't clear what you were saying about when, if ever, the company would do further testing. Even then, as I understood you, I just want to make sure I understood you.
Yeah.
You said even then it wouldn't be prudent, or they wouldn't be inclined to do further testing in this group.
Yeah, let me clarify that, because I think I may have left a misimpression about that. As I think all of you know, the FDA has elaborate processes for tracking the performance of the drugs it approves. And if it begins to see trend lines in those reports indicating side effects of various sorts, it will again look at the product to see if further statements in the label are necessary. The manufacturer of the product is usually very involved in that. At some point may engage the FDA to talk about, and this may be at the FDA's initiation, to talk about whether the label should be changed in some way to reflect these side effect reports. Part of that may be a determination that use of the product within particular populations should be limited or prohibited. And until some further studies can be conducted, that certainly has occurred. So I think when you get to the stage of reports of side effects that are coming in sufficient number that the FDA feels the need to look at that scenario may change, and you may have, as a result of that, some additional clinical studies that are required, or the conclusion may be reached more immediately to change the label in some way that would suggest restricted usage.
So, thanks, Alex. We can circle back, time permitting. Patricia, then Leslie, then Kavita.
Thank you, Bruce. My question relates to the fact that clinical trials are increasingly being done outside the US, and that may be particularly true for some drugs that may be targeted towards pregnant and lactating women. I'm thinking drugs to treat HIV/AIDS. And so I just wondered whether you could comment on, in general, companies consider liability coming from ex-US and whether that makes any difference at all that we should be concerned about.
Yeah. Let me start by saying that I'm certainly not an expert in the decision-making about which clinical trials a company may conduct outside the U.S. versus in the U.S., but I can react to part of your question, and that is to say that in terms of product liability with respect to pharmaceutical products, this is becoming much more of an international phenomenon. If you'd taken a picture 10 or 15 years ago, I think you would conclude that most litigation alleging defects in pharmaceutical products was focused in the United States. But it is now much more common, particularly in EU countries and Europe generally. And Australia certainly has a lot of litigation in this regard. And I don't know that that's necessarily motivating the locale of clinical testing with respect to products. There may well be other factors that are motivating a higher degree of conduct of clinical testing in markets outside the U.S., but I can confirm that there is much more product liability activity outside the United States than there was 10 or 15 years ago.
Okay, thank you. Leslie?
Thank you for taking the time to join us this morning. In your initial comments, you suggested that a variety of other factors are likely playing a stronger role in the decision to exclude pregnant people from research than fear of liability. I'm wondering if you could opine for us on what those factors are. And if you had a client who wanted to do this research with pregnant people, how would you advise them to think about those issues?
Okay. Well, I think the other factors that may be being considered are much the same as they are in the decisions to exclude other populations from clinical studies. And looking the research, I saw a lot of concerns about the exclusion of individuals above a certain age, the exclusion of persons with multiple conditions, particularly other conditions that may affect the outcome of the clinical testing, things of those sorts. And I think that those other factors are first, just the risks of consequences with respect to the participants in the study. In other words, I think with respect to pregnant persons, that those designing the studies may have concerns that there will be unexpected or unknown consequences from the study. You're testing a product and you're testing it because you don't know fully what side effects may occur. And so there may be a concern for reasons other than liability of subjecting subjects and fetuses to that in the same way that you worry about those things with respect to older members of the population and others who might be excluded. I do think that there's probably concern about complications in the process, in the clinical study process that might be caused by the inclusion of those individuals. And those can be a wide range of concerns, but I think just a worry that there may be complications that would arise that would slow the process and things of that sort. So I think there's just a range of other considerations that really are not liability focused that may cause that exclusion. In terms of your question about advising a client, I'm not, I think that the client in obtaining the waivers that are normally obtained from subjects in clinical studies, if you included pregnant persons in the study, the materials that you provide them so that they can make a knowing judgment about whether they wish to participate. You may want to include things that are more focused on their own conditions, the fact that they are a pregnant person and the potential ramifications of participation. I think you would want to do that, not only from a legal perspective, but also just to make sure that from an ethical standpoint, they're making a knowing judgment about whether they wish to participate in the study. But I think that would be the focus of my advice to the company in that regard.
Thanks. Kavita?
Thank you, and I apologize. I do not have a legal background, so my question may be less of that background than some of the other prior speakers. Much of the discussion focuses on causation and risk to one party, generally the fetus or neonate, without accounting for the balance of likely maternal benefit. And so I was curious if there's a legal or liability model or mechanism that allows for these claims of causation to be balanced by dual rather than solo party nature of these claims. So for example, in family law, overall global benefit or risks or goals are taken into account, and I wasn't sure if there was such a model in tort law.
Well, there's certainly those factors are certainly considered in tort law. If you put a product out there that is allegedly causing risks to users, it is part of the tort analysis frequently to consider the benefits of the product. So if you have an inherently dangerous product out there, courts and juries certainly will balance the benefit from that product and whether the warnings and training and things of that sort regarding the use of the product were adequate. So that is out there. Though it's difficult to see how that gets presented, though, when you're talking about clinical testing regarding the product. I think what you may have in mind is there somewhere in the legal process where it would be said, well, there would be risks of including a certain population in clinical testing versus the benefits of including them to provide greater certainty to physicians, to the learned intermediaries to understand whether they should recommend usage of the product to persons who are in that particular population. That's harder to envision because juries and courts are usually focusing on consequences of using the product as opposed to what I think is more of a policy question that's more in the FDA's bailiwick about what level of clinical testing should be required before it makes a determination of safety and efficacy, particularly with respect to certain populations. So yes, there's a balancing consideration in the legal process. I'm just not sure how focused it is on clinical testing when you get into real litigation.
So thanks. So Mimi, Arhize, and Mary, time permitted? Okay, Mary, then Arhize, then we'll keep going. Okay, thanks.
So I was very curious about what you were talking about earlier going back to the issue of gaining new information, increasing the liability of the company. And in particular about that, my question is it related to the company receiving the information and not adding it to the label? Or is it that changing the label post-approval creates a problem for the company? I'm just trying to get at the new pregnancy and lactation rule and requirements to be reporting about information with respect to what's known about a medication in pregnancy and lactation.
Yeah. I don't think what I was speaking about earlier was particularly focused on label changes as much as on sort of the abstract concept of I'm a company, I have FDA approval for the product, it is being marketed, and no particular issue has arisen with respect to any problems with the product. Nothing is being reported of particular consequence in that regard. But someone internally says, wouldn't it be good if we did a further study that was focused on a particular population that was excluded from the initial clinical testing? And that's really what I was getting at, to say that I'm not sure that doing that additional clinical testing would provide you much benefit in defending a product liability action brought by somebody who was within that population. And indeed, it may undermine your position because it would provide an additional target for the plaintiff's counsel to say that, yes, you did that testing, yes, certain results were achieved, but you didn't do it properly. The design of that testing was inappropriate in some manner. It just creates an additional area for debate before the jury if the matter goes to trial, and that you would be better served, one would argue, from a defense lawyer's perspective, by simply standing on the FDA's approval with the clinical testing record that existed at the time of the approval.
Thank you.
Doctor?
John, yeah, thanks for the elimination so far. My question goes back to something which you previously addressed on how courts approach causation in primary liability cases, especially when it involves birth defects. I was just wondering how science is kind of applied to these situations. For example, we know it's very difficult to prove causation when even in a science field. And how do they use things like causation diagrams, things like counterfactuals, things like, giving this drug before it happens, like happening in the first trimester, the pattern of anomalies. How does the science actually come to play in these liability cases? Is it, based on trying to argue for an alternative cause rather than trying to find out what actually caused it based on what we know around science? Thank you.
The way the science issues are normally presented in product liability cases is with the use of experts. Both sides will retain experts in the field. Both sides will try to identify an expert who can take the science and explain it to a jury in very simple terms, because assuming that the matter does end up going to trial, you will have a group of 6 to 12 individuals who have no legal training usually, and usually no background in the science, making these determinations, and they'll be very reliant on what the experts tell them about the product. I mean, normally the battle is that the plaintiff's counsel will say it's very obvious that whatever condition this plaintiff is experiencing was due to this product, and it caused it. And as I suggested in response to an earlier question, the defendant's expert will say no, that whatever experience this person had with the product, whatever injury they allegedly sustained, was due to other factors, whether they're genetic or behavioral characteristics of the individual. But they will argue that there is no connection between the product and whatever that individual experienced. I smile a little bit when you talk about the science aspect of it, because it's certainly there. But I think that those of you who are immersed in science, if you saw the way it gets presented to juries at trials, you would be somewhat aghast, because it really is boiled down to very simple terms. And frankly, in these trials, it often becomes more a matter of a layperson's believability of one expert versus another. I don't know if that responded to your question, but the science is there, but it's in a very simplified form.
So with apologies, I know there's more questions in the room and online, but we're over time now. And so with that, join me in thanking John for this informative session. And we'll move on. Thank you.